Welcome to an oral argument session of the 5th District Court of Appeal. My name is Jay Cohen, unless you don't like the result of this case, in which then I'm John Harris. Judge Harris is out ill, but I have read all of the briefs in the case. I have reviewed much of the record, but not all of it. But to the extent that that becomes an issue, I will make the effort to familiarize myself with it. But in any event, we also have on the panel this morning Mary Alice Nardella from our court, and then we are privileged this morning to have from Seminole County Judge Melissa Soto. So we welcome Judge Soto to the court. As I indicated to you, these are being reported on YouTube to the extent that might influence you in some way. I don't know how it would, but just be aware of that. We've got the case of Crosby versus State Farm, Florida Insurance Company, case number 2202. Set this morning. Both sides will be entitled to up to 20 minutes each for their argument. Mr. Nation, my default is for 5 minutes of rebuttal. If you'd like something different than that, just please let me know and I'll be glad to accommodate you. So,
yes, sir.
That said, we are ready to proceed.
Yes, sir. May it please the court, counsel, and Judge Cohen and I will reserve 10 minutes for rebuttal. I don't anticipate using the whole time.
All right. No penalty.
Yep, I understand. In this case, I just want to talk about the posture that we approached summary judgment with. As we went into the summary judgment hearing, State Farm had agreed that this claim or these two claims were covered. And I just want to talk about the areas in which they did that. And I'll talk about the summary judgment motion. And they're covered. Yes, sir.
Go ahead, Judge Nardella.
Yeah, yes.
We just have such short time, Mr. Nation. I know there's a lot of issues here. And I was hoping that we could go through the items of damage, or also known as physical loss when you talk about them. And I just wanted to direct your attention to the interrogatory answer that your client gave, if we could start there. He was asked to list each item of expense or damage that had incurred as a result of an incident described in the complaint. And he went by both incidents. So the first one, he named the July 2015 incident. And he says there was damage to the floor tiles and grout in the laundry / utility room.
Yes.
Is your position that the damage to the floor tiles and grout in that room exceeds the amount of the deductible?
If we were only dealing with the water that touched the floor, then we don't have a separate number for that. I don't know that it does or doesn't exceed the deductible, but that water damage that's in that room triggered the coverage. It was enough to trigger the coverage. State Farm acknowledges that. And our claim is the resulting damage to the structural fill supporting the pipes and the slab, it should be included in that number.
So when we
and the tear out.
When we talk about the structural fill, when we look at how we define dwelling in the policy, what is the structural fill in your position? Is the structural fill land supporting the dwelling, or is it something else, and why?
It is not the land. When you buy the lot, you're buying the land. When you enter into a contract to do the construction, then the contractor brings in the structural fill. And I have this in the affidavit of Ms. Northwest. Has the structural fill bought in? You pay the contractor for that. The structural fill is compacted by the contractor. By code, it's required to support the pipes, surround the pipes, and then it also goes above the pipes and supports the slab. The slab plus the structural fill equals the foundation. And so those are structural components of the house. You can't have a foundation that's just a slab. You've got to have the structural fill. And I've spelled that out and I think lots of areas in Ms. Norfliss's affidavit. And so those are not the land. The land is what we purchase when we buy the lot. The structural fill is part of the construction process and and specifically is a material used in the construction of the home. That's in her affidavit.
Okay.
So I hope that clears that part up.
It does somewhat. Is there any case law to support that position? Though I understand that's her expert position, that it was brought in, it was compacted so that we could have a strong foundation. But is there any case law to support that the structural fill is not the land, but actually material that is brought to the construction process, which becomes something other than the land once it's compacted?
There are no cases on it.
Okay. When we look at the slab itself, you did a nice job of explaining that the slab is permeable. And so when there was a leak, it permeated into the slab and that caused damage.
Yes.
Is there a claim being made for the slab damage itself?
There is.
Okay.
There is a claim for the slab damage itself. And if you'll picture a bounty towel, it wicks up, and the same thing happens in the slab. The sewage wicks up into the slab. Now, what happens is there's going to be a trench to get access to the failed plumbing system. There will be a trench that is trenched out over top of those pipes. That's the damaged slab part that needs to come out. That's going to come out as a result of getting access to the pipes. And so that part, that damage is part of the tear out costs. We're not asking for it twice.
Do we need to get access to the pipes? Because Mr. Bellamy's deposition stated that when it comes to the drain line, he would just seal it and work around it. Isn't that right?
Yeah, well, and that can't be done here because that would leave the damaged structural fill. It would leave the sewage underneath the house. It would leave the damage to the slab, as well as that which is wicked up underneath any tiles. And so that can't be done. It's not an alternative fix. And our people have put in their affidavits. Ms. Norfliss has put in her affidavit. And if you look at the report of Frank Gay, that is not a reasonable repair. The only reasonable repair is access to the entire system. And there's specific coverage for that in the policy. State Farm recognizes that issue and therefore gives coverage to tear out portions of the building necessary to get access to the system. And that is an additional coverage they provide to their insureds.
Part of the tear that you're requesting is in the ceiling. And that sounds like that's a replumbing, not anything else other than replumbing, which State Farm wouldn't cover. Why, when you have a leak underneath the slab, do you think that you're entitled to tear out damages in the ceiling?
That's a great question. Now that is only dealing with the supply line leak. And so when the supply line leak, you'll see Ms. Norfliss talks about a void. That's the structural fill underneath and has caused damage. That damage then results in cracking, which includes the ceiling. Now that's a factual issue, and State Farm recognized that that was a factual issue and it was a resulting damage, or at least we're claiming it's a resulting damage, and they're saying it's not. And I very well may lose that in front of the jury. I don't know. But I do know it's a factual issue whether or not that is a resulting damage from the supply line leak. And that is only a very small part of the claim. And here we walked in, they didn't even ask for complete summary judgment on the entire claim. And they got something they didn't even ask for. Because our trial judge said, none of it's covered. None of it's covered. They didn't even ask for that. For their drain line claim, the very first request from them is simply summary judgment that repairs to the plumbing system are not owed. We didn't ask for anything for the plumbing system. Their second, yeah, go ahead.
Oh, so sorry. When it comes to the supply line claim, your expert testifies that it created a void because of the leakage from the supply line. That created the void. The void
Correct.
created problems with the floor, the sloping, problems with the wall, and also problems with the ceiling. Is that a direct physical loss when when it's the void that creates the problem, it's the water that creates the void creates the problem? So
it is direct physical loss. And I do want to make a point that is what triggers the coverage. Direct physical loss triggers the coverage, not damage. Those two things must be a little bit different, although we use them offhandedly, somewhat interchangeably. But the pipes were defective, or that was the supply line claim, and it allowed water to go underneath the slab into the structural fill, resulting in a void. That's damage to the structural fill. Now, what did that result in? The slab moving, yanking down the walls, and tearing the ceiling. Now, we're going to have a factual dispute with State Farm at trial, hopefully, over that issue, but it's certainly not summary judgment. Coverage restrict. Go ahead.
What is the evidence in the record? And I understand the burden's different, but from your perspective, what is the evidence in the record that shows that the issue from the supply line was caused by something other than continuous or repeated seepage or leakage?
Actually, it's the opposite. Is what happened is, due to wear, tear, deterioration, and corrosion, the supply line began to leak. That immediately caused damage. That isn't a long-term loss. What's excluded under their long-term loss is something like drip, no damage, drip, no damage, drip. And over time, that drip causes damage. What we have here is the supply line broke and immediately caused damage to the surrounding areas. But even if it didn't, the fact that it's now broken entitles us to tear out to get access to that system.
But not if you're going to run it overhead, right?
No, I mean, we're not asking, I would not ask the jury, and if that we're not asking the jury for the replumbing or the repiping at all. The plumbing system itself is not covered. We don't get anything for the plumbing system. I agree completely with that.
But you're not entitled to tear out to access where the water comes out, right? If you're not tearing out to access to stop the leak, if you're going to replumb it.
You're entitled to, the tear out says if water damage is caused as a result of a plumbing leak, then you're entitled to get tear out to get access to the cause, meaning the pipes. But you don't get the pipes themselves.
And what's your best evidence that it wasn't drip, 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 drip? What's the best evidence? Go ahead.
Yeah, it broke the supply line broke at a moment in time, and then the water meter went up immediately. His bill was much higher than usual, and so it broke at a moment in time, and then the meter started spinning. But I want to get back to what you're talking about is the Hicks case. It's my case out of the 5th ECA, and what Hicks tells us is the insurance company is responsible for all of the water damage up to the point where it becomes over a matter of time. Now, that's kind of odd because State Farm's policy says they don't pay for a loss which occurs over a period of time, but they do have to pay for all of the loss that occurs before the expiration of that, quote, period of time. Now, Hicks was 14 days. Hicks specifically said, we won't pay for anything loss that occurs over 14 days. State Farm said, yes,
Hicks
sir.
Specifically the language of that policy.
Yes. And in this policy, what State Farm says is they won't pay for loss that occurs over, or water damage that occurs over a period of time. They don't define it. And in some context, that over the period of time can be ambiguous. The only case on it was a loss that occurred. It was a State Farm policy, a loss that occurred over, I think it was like 6 months, and it was damage that occurred over a 6-month period. And in that case, there was no dispute that that was, quote, over a period of time. But in this case, that in 1 month, his water meter is fine. The next month, he gets the bill and it's significantly higher. We can pinpoint in the water bills when it broke and show that to the jury.
Mr. Nation, this house was what, 60 years old?
You may know better than I don't recall the date, but usually if it's a cast iron pipe system, it's going to be built before 74, and most of these are in the 60s or late 50s. I don't remember the date of this one.
Because it sounds almost like, State Farm, you want State Farm to, ensure, in perpetuity, plumbing that we know isn't going to last in perpetuity.
Well, we know the plumbing deteriorates over time. The cast iron pipe that's inherent with it is going to have rust, deterioration, and corrosion, and will fail over time. This one did collapse. And that's why State Farm gives an additional coverage that specifically says, and I can read the tear-out coverage. If a loss to coverage A, that's just the house. If a loss to the house is caused by water escaping a system, so here it's a plumbing system, we will pay the reasonable cost you incur to tear out and replace only that part of the building owned by you that necessary to gain access to the specific point from which the water escapes. So they give that coverage. Now we have a factual fight with them. They say it escaped from one point. We're saying it escaped, and we can show it through our videos, escaped throughout the entire system. There are cracks throughout this entire pipe. And so Judge Cohen, that is exactly the coverage they gave, is that they said if that happens, they will give us access to those pipes. To let them off the hook would just let them collect the premium and not have to pay for that portion of the coverage, that additional coverage that they've given to my client.
Or you're at a little over 5 minutes. How would you like to proceed?
I think question and answer is much better than me droning on. So if no other questions now, I'll let Mr. Samus have at it.
Okay, very good. Mr. Samus?
Thank you, Your Honor. And may it please the court, Scott Samus for the Appalachia State Farm. I want to begin with Judge Cohen's comment. What this case illustrates and what the trial judge perceived is the difference between an insurance policy and a home warranty or maintenance contract. There are certain expenses when things wear out on your house that's your responsibility to fix them and to prevent damage that results from allowing a pipe to essentially disintegrate under your house and then water to back up.
Mr. Samus, yes. Let me ask this. Do you believe that resulting damage from under the slab from cold water supply line leak was covered?
No, Your Honor.
Then what would you say? Because Mr. Nation cites to pages 1104, 1105 of the record where State Farm seems to say that they do admit that is a covered claim.
No, that is not a covered claim, and that was the topic of the motion for summary judgment. If we're talking about the joint pretrial statement, obviously the joint pretrial statement are things that are contingent if the motion for summary judgment is not granted.
Well, you did see that in his brief, did you not?
Yeah, what the only thing that they said there would have been coverage for is mopping up the water. And what appellant has argued in their brief is that by filling out a joint pretrial statement and saying that these are the issues to be tried, but when you continue to read on, it says that the summary judgment needs to be decided. So what the joint pretrial statement says is that the issues to be tried, issues to be tried are subject to a motion for summary judgment. If this court writes an opinion that says if you suggest jury instructions, if you file a motion in limine, anything that you want to preserve, in case the case goes to trial, that somehow you waive your motion for summary judgment, then defendants would never be able to participate in pretrial statements. This is obviously subject to the motion.
No, that's not how I interpreted it, but I'll look it over again after the oral arguments. What is your position in terms of the compacted? I mean, it's compacted dirt is what it is that's underneath the slab. Is it your? Do you disagree with the assertion that is part of the structure for purposes of your policy?
Absolutely disagree with that, Your Honor. The slab and the footers are the physical part of the dwelling. The policy says that we do not cover, and under coverage A, land, including land necessary to support any coverage A property, costs required to replace, rebuild, stabilize, or otherwise restore the land, and the cost of repair techniques designed to compensate to prevent land instability. That's what this complaint is exactly about.
Uh-oh.
Move around to level
All right,
under a house or to fill under a house.
you froze on us for just a second. So why don't you go ahead and back up on your last thought?
Okay. Under this definition, first of all, there's never been a case that says that the dirt under the house is part of the coverage A property. The only time in the history of Florida's jurisprudence where the repair of the land has ever been covered is in sinkhole cases, because the sinkhole statute requires remediation of sinkholes. There is not a single case where water seeping under the ground and permeating the ground underneath the house has been found to be coverage A property. That's because it says the land under the house is not covered. Now, if you move, think about the consequences of making a ruling that the dirt between the slab and whatever the rest of the earth is, that somehow that becomes part of the house. Then is the whole earth part of the foundation? Because, you know, the ground that's touching that may have been moved from the other side of the lot, and now it's been moved in an apartment complex. I mean, where does that end? The policy reasonably read is the dirt under the house is not coverage A property. The slab and the footers is coverage A property. And that
what do you do with the slab? So the slab is coverage A property, right?
Correct.
Why is the slab, why should there not be compensation for the slab?
Because the only mechanism of damage to the slab, when you look at Norflus's testimony, is the cracking and the subsidence and cracking of the structure due to the erosion under the house. This idea that somehow the presence of the slab being wet from underneath caused property damage, and it's wet cement that's wet, that's outdoors. There's no description of how, other than the cracking and the subsidence, that water under the house, wastewater under the house, damaged the slab. There's no description of that. There's no water in the house. Nobody said it has come up through the house and is doing something to the floors, doing something to the cement underneath. The affidavit from September 4th, 2019 is very telling. It was drafted in an effort to create coverage for the slab, but when you read it very carefully, it says that the water is going under the slab. It's permeating the foundation system. Now, what Ms. Norflus wants to do is wants to lump in together and call the foundation system the dirt and the slab. And then in her last paragraph says the sewage contaminated fill must be replaced. So when you read this in its totality and you see what she is saying, is that this leak under the house is eroding and permeating the soil, the dirt, which is not covered. And the only mechanism of damage to the slab is that there's a void and the slab is sinking into the earth. There is no statement about or describing the damage to the slab itself. The damage, the effect on the slab is covered by two exclusions. And remember, the resulting loss cannot itself be a loss not insured. Repeated seepage and leakage is exactly the mechanism that is being described here. The only testimony, the only evidence as to what kind of a leak was under there is this 0.17 gallons per minute rate, which was described as a slow leak. This is a classic. The reason he got a high water bill is because he's got a slow leak.
But didn't that occur later? I mean, wasn't there an initial period of time where it wasn't a slow leak, where the meter was spinning, indicating a sudden leak?
No, there was a leak inside the house from one of the handles in the faucet, and those were fixed. And then the remaining leak was undisputedly 0.17 GPM, which was described as a slow leak that was never contradicted by anybody. So whatever that leak under the house was, a leak doesn't go from big to being small. I mean, if it's 0.17 when the experts are out there, leaks don't heal, they don't get better, they get worse. So this was always, the line breaks, the supply line is leaking, a slow leak under the house the whole time. Repeatedly, if the drain line every time you flush a toilet, every time you empty your sink, this is classic repeated leakage and seepage.
All right, again, Mr. Samus,
then
excuse me, after you hit drain line on that first statement, you froze for a little bit. So if you could back up and go from, you were discussing the drain line, and go back from there.
Okay. Then when you think about the drain line aspect of it, what's the mechanism of how the drain line is eroding the soil? Every time the toilet flushes, there's a repeated leak. Every time you empty the sink, that's repeated leakage and seepage. And this really gets back to the original point. When insurance policies don't maintain property and they don't maintain this kind of thing, when you have a rotted pipe that is bleeding underneath the house, it's the homeowner's responsibility to fix that. And you cannot let your house fall into ruin and then make an insurance claim. I mean, insurance would be unaffordable for anybody or practically anybody.
How old was this house? About 60 years old? Do I have that right?
A little less. I think it was 55, maybe. It was close. It was between 50 and 60, though, okay. Certainly. And which is, the evidence is these things rot and fall apart. And if you let your house, I mean, when you do a workaround and you are essentially dumping the water into your yard and ignoring the problem, these things are going to happen. And the erosion under the soil is something.
Well, are you talking about the homeowner's repair from the laundry room? From the laundry room,
right.
Well, but is there any evidence that impacted the damages here?
No, but my point is that this is the distinction between the need to make repairs, and nobody says that the pipe is covered.
Mr. Samus, what do you say
Yes.
about the Hicks case? I understand that language is particular, and I'm guessing you're going to go there. Can you explain that to this court?
Correct. The Hicks case is limited to that policy language because essentially in Hicks, the policy said that we don't cover damage caused by repeated seepage and leakage over 14 days. So the court looked at that plain language of the policy and said, well, that means you do cover it up to the 14th day. The only case that has interpreted State Farm's language is the Hoey case. And the Hoey case, there was a leak, and they couldn't tell that whether it was 3 weeks. I think the people were out of town, and they knew it was between 3 weeks and several months. And they said, even though it does not have a precise deadline, that is over a period of time. That is what the kind of loss that this language pertains to. So this one, we have a leak that started in 2015, isn't reported to State Farm till 2017. This has been going on for 19 months before we even hear about it.
But that's only the drain line,
classic.
right? The supply line, we don't have an evidence of a 2-year delay. Is that correct?
The supply line, no, there was not a delay. When the bill went up, they went out and saw the supply line. But the supply line obviously had been leaking for a month because his water bill went up, and he gets his water bill after several weeks or a month, and the water bill is up.
I think at first he saw water coming from underneath the house, which indicates a fairly substantial break as opposed to a drip, drip, drip.
Well, I don't think you can conclude that. The sworn evidence, Your Honor, is that once that they fixed the leak in the shower and the hose bib, that the leak was a slow leak. It was 0.17 GPM, which was described as a slow leak. So what could have happened is that supply line is leaking very slowly under the house, and it took 3-4 weeks, a month for it to come up to the surface. It was only 2 feet inside the wall. So it's not unreasonable to think, well, if 20 gallons had leaked out over the period of 3 weeks, it's going to start showing on the surface.
Are these questions of fact that a jury should be determining rather than the judge?
No, our entire argument, Your Honor, is accepting everything Kathleen Norflus said is true. She described the mechanism of the damage to the earth. The ground is not covered. She described the mechanism of damage to the walls, the cracking. All of that is settling or cracking of foundation wall. Precisely fits the cracking,
All right,
settling
you
exclusion.
froze
So we
again
have two
at
exclusions.
foundation. So if we can
Okay.
back you up at foundation.
Okay. If the mechanism of damage that Kathleen Norflus describes is exactly matches two exclusions. Not only the repeated seepage and leakage, let's say that doesn't even exist. You've got settling, cracking, shrinkage or expansion of foundation, walls, floors, roofs, or ceilings. So this entire part of the claim where there's this erosion in the dirt, which is not coverage day property, and the resulting cracking of the walls, that is excluded. It can't be resulting damage because a resulting damage cannot be a loss not insured. Cracking of foundations, walls, roofs, and ceilings is not a covered loss. The same thing goes for tear out.
What do you say to
be a loss
Mr.
insured
argument that it's a direct physical loss as a result of water instead of
we agree that there's a direct physical loss. The question is it excluded? We understand that cracking is a direct physical loss. The question is both of his theories of recovery require a loss insured, If the loss is excluded, it is not covered by tear out and it's not a resulting loss. Resulting loss, for example, with resulting loss would be you have some sort of deterioration and there's a collapse or a crack in the wall and it breaks a gas line and there's a fire or an explosion. Because when you look up at the excluded damages, fire isn't in there, explosion isn't in there, and those are common types of resulting loss. But when you look up at cracking and you look at loss caused by repeated seepage and leakage, those are excluded. And therefore, the resulting loss provision upon which they rely does not afford coverage. And the tear out does not afford coverage because tear out requires a loss insured to coverage A. The land is not covered.
Since there's a dispute about the particular location of the supply line leak, why does that not matter? Because you don't have to go in and fix that leak under the supply line? Can you explain that?
You don't have to fix it because it's not covered. It doesn't matter where it is. The deterioration, the cause of the need for a new supply line is wear, tear, deterioration, corrosion. That's been admitted through this whole thing. So it doesn't matter where it is. It doesn't matter where it caused the subsidence and the erosion or cracking because the erosion under the ground is not covered, and cracking of foundations, walls, ceilings is not covered. So the location is irrelevant. The location is irrelevant. It's the nature of the damage, it's the mechanism of the damage, and it's the cause. And when those things are compared to the exclusions in the policy and the requirements of resulting loss and the requirements of tear out, when you eliminate those, there's no coverage left. And there's the reason why these things are filtered out comes right back to that. You can't let the reason the policy is drafted in this way, and it's hard to draft a policy, and that's why these things are so difficult to sort of work your way through, because it's hard to draft a policy because of the many ways that the house can be damaged and the many causes and things that impinge on houses. You have to create these filters in a insurance policy. And what they do is they filter out situations like this, where the house is wearing out, the pipes are wearing out, or a roof is wearing out, you don't do anything, and they start leaking under the ground. Those things are not covered. And then the subsidence, all of those things are excluded, and rightfully so. And if the ground, if the soil, the dirt under a house were covered, we would certainly have a case in Florida that says that. But if you look for, one of the famous sinkhole cases is Chulura. And they were talking about why is the ground covered? And the reason the ground is covered in sinkhole is because there's a statute in Florida that says you've got to fix the sinkhole, which is the ground under the property. And the policies have to provide that coverage. Otherwise, not a single example of fixing the dirt is covered. And if the
Mr.
dirt
Samus,
is covered, yes.
I'd like you to keep just a little bit of time, because I would like you to go to 1104 and 1105 of the record, and I'll let you do that, right after Mr. Nation's rebuttal, just to clarify for me the context of the statements that are contained within that section of the record. Can you do that for me?
I'm going to do my best right now.
All right.
All right, thank you, Judge.
And is there anything else that you want to say before you get to that point?
No, Judge, I'll work on that right now. 1104, 1105.
Right. All right, Mr. Nation then. And Mr. Nation, if you need an extra minute, I'll go ahead and give you that.
I appreciate that, Judge. There's a couple points I've just got to make. One is they did not move for summary judgment on the constant and repeated leakage or seepage or the cracking on the drain line claim. They only moved for summary judgment on those two things in the supply line claim. Now, we have a dispute on the supply line claim about when the damage is onset and whether it was immediate. But they didn't even move for summary judgment on those two grounds for the drain line claim. One. Next point, if you look at Ms. Norfless's affidavit, and I'm looking at page 2415 of the record, she describes the structural fill in footnote 1. Standard slab on grade construction of this nature is for backfill, which is clean sand to be delivered to the construction site and compacted. And the cast iron pipe plumbing system is then placed in the backfill, and a concrete slab is poured on top to become the floor of the home. It then goes on. Yes, sir.
Dirt. No matter how you dress it up, it's still dirt.
It is dirt, clean sand, and here's what the policy says. And so if they don't define it other than to say they cover the dwelling, and the dwelling includes materials that are used in the construction of the premises, that's B. And C, it covers the foundation, the floor slab, and footings supporting the dwelling. This is part of the foundation. To the extent they say it's not, and you find, all right, both sides have made a reasonable argument, then it's ambiguous and has to be interpreted in favor of the insured. It then goes on to say they don't cover the land.
That's a legal, I think that's a legal issue. I don't think that that's a factual issue as to whether fill constitutes part of the structure or not.
I agree with you. I agree. That's an interpretive issue. Jury doesn't get to decide that. And we've put on record evidence that it is part of the foundation of the home, and it's uncontroverted. It goes, yes.
Can I bring you back to your first point regarding what they didn't claim as for exclusions when it comes to the drain line?
Yes.
When we look at the drain line, please correct me if I'm wrong. We have the laundry room damage, the staining to the ceiling, the grouting damage, the tile damage. And then I go to Mr. Crosby's depot. And when it comes to the drain line, I read on the record on 1394 him to say there's no other damage to any other room. Is that wrong?
That is for him, for his personal information, that is correct. Obviously, he doesn't know about the damage to the structural fill, nor does he know anything about damage from the water or sewage wicking up into the foundation. And by the way, that issue—
if the fill is not dwelling, then they don't need that exclusion to apply anyway, because it doesn't come within the grant of coverage.
Yeah, but that would be I think, a misreading of the policy to say the structural fill isn't part of the dwelling. I mean, the only evidence is that it is. The contractor was paid to bring it to the site and to work it into the support for the pipes and for the slab, creating the foundation. That's what we have.
Give us any case anywhere that says that.
There's not a case either way on that issue. Either way, and sinkhole, it's, go ahead, I'm sorry.
I just want to make sure I'm not restricting you to Florida.
No, there's no case either way.
Anywhere in the United States that holds that that the fill, whether it's compacted or not, forms part of the structure for insurance purposes.
There's no case, because that is a, either way, no case saying it is not, no case saying it is, except mass ponds, which is, we've cited, and here's what it says in mass ponds: the pipe broke in that case underneath the house. And here's what it said: examining the plain language of the insurance policy, it's clear the failure of the drain pipe to perform its function constitute direct physical loss. In this case, it said there, at this point, there is no evidence that the water exiting the pipe has caused any damage to its surroundings. And then the court went on to say, it's not, it wouldn't be surprising that that evidence would be discovered later, and therefore we're not going to grant summary judgment at this time. And so they recognize that the surroundings to the pipe would be covered in mass ponds, and specifically say it. And I don't know how we can have a general contractor who's saying this is part of the dwelling, and then State Farm just simply says it's the land, when the word land is undefined, but the coverage extends to the foundation that's and slab. They treat those two separately, foundation and slab. And our contractor has said that the foundation consists of the slab and the structural fill. And so they have no evidence on the other side of that at all, that this is the land. The land would be purchased from the seller of the land. The structural fill is worked into the foundation. Let me see if I have anything else. I don't know if you want me to answer any questions about 1104 and 1105, but.
Well, let me do this, Mr. Nation, which is, let me let Mr. Samus, address that very quickly, and then I might give you, 30 seconds to respond, and under the theory that you get the last word.
Yes, sir.
All right, so Mr. Samus.
Yes, Your Honor, I've got the section you're talking about here. It says, it is an undisputed fact there is an underslab leak in the cold water supply line around the dividing wall between the living and family and laundry room. Here, any resulting damage to the property from the underslab cold water supply line leak would be covered under the policy to include tear out. Now, that's not an admission there's coverage. That says if there were resulting damage. But as I have argued, there is no resulting damage from that area. And what that's talking about, Judge, is, for example, and this is a very common kind of covered cause of action. Let's say Mr. Crosby wasn't home, and this thing burst and sprayed all over the laundry room and soaked into the cabinets and the wall and destroyed drywall and all that kind of thing. That would be covered. That didn't happen. Then it goes on to say, however, no damages were observed to the property resulting from the underslab leak to the property under the underslab leak, and therefore no payment was rendered. Therefore, the only covered tear out would be if there were resulting damage in that laundry room. They would only be able to get money to tear out where it was necessary to get to that leak. The problem is that this conversation in this part of it is talking about if there had been damage in that laundry room. The resulting damage is covered. The damage underneath the surface to the dirt is not resulting damage because it's not coverage A property.
All right.
So what
Thank you, Mr. Samuels.
Okay.
All right, Mr. Nation, very briefly in response.
Ultimately, the trigger for coverage is the water escaping that pipe entering into the laundry room. That triggers coverage, and then that triggers the tear out coverage. The extent of the tear out coverage is going to be a factual question. Now, I believe that the structural fill is also part of the dwelling. Doesn't have to be to trigger the coverage. We've already got coverage triggered, and now it's a factual issue for the jury to decide the extent of that tear. Thank you, Your Honor.
All right, thank you both. And let me say, it's always a pleasure to have lawyers that are so thoroughly prepared, and the case was well briefed and well argued. So thank you both.
Thank you,
Thank
Your
you.
Honor.